Good afternoon, everyone, and thanks for joining us for a Tax Practitioners Board webinar. My name is Julie Shaw, and I'll be hosting today's session. Now, we've created this webinar to connect directly with you. We value your opinion, and today's an opportunity for you to raise any questions you have directly with us. Now, following the webinar today, we will provide you with a copy of today's presentation and some useful hyperlinks, and we'll send these to you via the email address that you used to register for today's session. You can also access them by visiting our Webinars Resources Hub on our website at tpb.gov.au/webinar-hub. I'd also like to remind you that today's webinar will count towards your continuing professional education, and you can claim 1 hour for attending. However, just note that we do not issue attendance certificates. So let's look at what we'll cover today. In today's webinar, we'll help you understand the sufficient number requirement under the Tax Agent Services Act 2009, or TASA for short. We'll also look at relevant considerations to determine if adequate supervision and control exist in your practice. Now, this will include where you might have remote supervision arrangements in place, and also if you provide supervision for one or more related or unrelated entities. We've included some scenarios and case studies in the presentation, and they'll help you better understand the context of the sufficient number and supervisory arrangement requirements. And then finally, to finish up today, we'll answer some of the common questions we do receive during the webinar, so make sure you submit those questions to us via the chat box today. So before we begin today's presentation, I'd just like to conduct a quick poll so that we can just get a feel for who's in the audience with us and in what capacity you're joining us today. So the poll will just pop up on your screen in a moment, and all we want you to do is provide an answer to the question. And the question is, what type of tax practitioner are you? And we have 3 options for you. The first one is supervising tax agent. The second is tax practitioner under supervision, and the other option we have is other. So I'll just launch that for you now, and I'll give you a moment to put your responses through. Okay, it looks like we've got a few responses coming through there. Okay, thank you everyone for putting through your responses there. We will just stop that poll, and the results that we've got so far are 59% of people are supervising tax agents, 8% of you are tax practitioners under supervision, and about 38% of you are under the other category. Okay, so now I'd like to welcome our board member, Craig Stevens, who will be presenting today's webinar. We also have Madeline Savos on the line, and she'll be helping out answering some of the questions that come up in the chat box. Madeline is one of our policy advisors, so she'll be quite capable of responding to any questions you've got coming through today. So thank you, Craig, for joining us today. I'll hand over to you now to begin the presentation.
Terrific. Thank you, Julie. Thanks very much. Good afternoon, everyone, and thank you for joining us. As Julie indicated, we will be discussing factors you should consider to ensure there is a sufficient number of registered individuals to provide adequate supervision and control in your practice. You may be aware that we have recently finalised our public consultation on the draft information sheet on this topic and are currently considering all the feedback we've received before finalising the guidance. This should be complete in the coming months, so keep an eye on the e-news and social media channels for updates. And I should say thank you to all those who have provided feedback to us on that draft policy. Today we'll be providing information that will help you understand our approach regarding this important aspect of managing the tax practice. Having a sufficient number of registered individuals to provide services to a competent standard and to oversee the supervisory arrangements in your practice are mandatory requirements under the TASA. These requirements have become particularly important in this pandemic environment with many people working from home, as I'm sure many of you are. Also, with the continued advancements in technology, remote working arrangements are increasingly becoming the norm, including in our tax practitioners' businesses. So today's webinar will focus on helping you to ensure you're meeting your obligations and have adequate supervision and control in your practice. So let's begin. Firstly, I'll have a look at the legislative basis for the sufficient number requirement and the requirement to have adequate supervisory arrangements in your practice. So there's a requirement under the Tax Agent Services Act of 2009, or TASA, which we use for short and we'll use through this presentation, that all companies and partnerships meet the sufficient number requirement when registering or renewing their registration. This requires companies and partnerships to have a sufficient number of registered individual tax practitioners to provide tax agent, BAS, or tax financial advice services to a competent standard and to carry out supervisory arrangements. When we say a company or partnership must have a sufficient number of registered individuals to provide services and supervision, this means in the case of registration as a tax agent, these individuals must be registered tax agents. In the case of registration as a BAS agent, these individuals can include registered BAS agents or tax agents. And in the case of registration as a tax financial advisor, also taking into account the relevant requirements of the Corps Act, the registered individuals can include registered tax financial advisors or tax agents. So the relevant requirements of the Corporations Act state that a financial services licensee must have adequate resources, including financial, technological and human, available to provide the financial services covered by the licence and to carry out supervisory arrangements. And they must maintain the competence to provide those services, as well as ensuring that its representatives are adequately trained and are competent to provide those financial services. In addition, all registered tax agents, BAS agents and tax financial advisors must ensure the services provided on their behalf are provided competently. This includes ensuring that there are a sufficient number of individuals within the practice to carry out supervisory arrangements. The sufficient number requirement. The purpose of including the sufficient number requirement in the TASA is to ensure a partnership or company practice has sufficient organisational qualifications and experience to provide tax agent, BAS or tax financial advice services competently. Now, I must emphasise here that the sufficient number requirement is not just on registration or renewal, it's an ongoing registration requirement. This means if your company or partnership practice ceases to have a sufficient number of registered individuals, the entity will not be eligible to remain registered. So you must ensure there is always an adequate number of registered individual tax practitioners in your entity. You also have an obligation to notify us when your company or partnership ceases to meet this requirement. The TASA requires that any changes affecting registration must be notified within 30 days of you becoming aware or when you ought to have become aware of that change. Excuse me. We'll discuss some factors to help you determine if you have sufficient number or a sufficient number of registered individual tax practitioners in your practice shortly. Before we do, let's look at the legislative basis for supervisory arrangements. The supervisory arrangements are relevant in the context of the Code of Professional Conduct, or Code, we'll use Code for short, the civil penalty provisions in the TASA, and when considering relevant experience. Looking at these individually, the Code of Professional Conduct. So the Code sets out the professional and ethical standards required of tax practitioners, including the obligations you have to your clients, the TPB, and in relation to your own conduct. In the Code 7, the registered tax practitioner must ensure that the tax agent services they provide or that are provided on their behalf are provided competently. Now, when I refer to tax agent services in this context, I'm collectively referring to tax, BAS, and tax financial advice services. So in the Code Item 7, you are ultimately accountable for tax agent services provided on your behalf, and you need to ensure that those services are provided competently. In order to comply with this code obligation, you must ensure that adequate supervision and control arrangements are in place, services are provided to a competent standard, and appropriate disclosures to clients is provided. Now, in the context of the civil penalty provisions in the TASA, having adequate supervision and control arrangements in place is important and relevant for registered tax and BAS agents who sign declarations in tax documents or other statements in relation to a taxpayer. The civil penalty provisions basically prohibit registered tax and BAS agents from signing declarations or other statements that have been prepared by an individual who is not either a registered tax or BAS agent, or who is not working under the supervision and control of a registered tax or BAS agent. That supervision comes in there. And then for relevant experience, in the context of relevant experience, supervision and control is relevant and important for individuals who are seeking to register with the TPB as a tax practitioner for the first time. The Tax Agent Services Regulations of 2009 require that individuals wanting to register with the TPB meet the relevant experience requirements. And one way individuals can demonstrate that they have the required relevant experience is by working under the supervision and control of a registered tax agent, BAS agent, or tax financial advisor for a certain period of time, depending on the type of registration they are seeking. Therefore, appropriate supervision and control by a registered tax practitioner is an important part of them gaining that relevant experience. Right, so now that I've given you the legislative background for these requirements, let's discuss them in some detail to see how this applies to your practice. Starting with the sufficient number requirement. When we talk about sufficient number, the obvious question that arises is how many registered individuals should a company or partnership entity have? And it would be easy if there was a set formula to work this out. Unfortunately, there's no such thing, as each tax practitioner's circumstances are different and unique. To satisfy this requirement, though, there must be at least one registered individual nominated to provide tax agent services on behalf of the entity and to provide supervision and control within the practice. Nominated registered individuals for your entity can include individual partners, directors, employees, contractors, and staff provided under a service trust arrangement. For a partnership or company tax financial advisor, in addition to the individuals I've just mentioned, the nominated supervisors can also include financial services licensees representatives, such as authorised representatives, responsible managers, compliance officers, and regional aligned managers. So determining the sufficient number. I mentioned earlier there must be at least one registered individual for your entity to meet the sufficient number requirement. But this does not mean that if you have one registered individual, you would automatically meet our requirements, as the appropriate number will depend on the circumstances of your individual practice or company. So you need to consider a range of factors to determine if your practice has a sufficient number of registered individuals. Now, this is not an exhaustive list, but you could consider the following. Do you have adequate financial, technological, and human resources to provide the tax agent services and provide supervision? Is the registered individual competent and adequately trained to provide effective supervision and control? What is the size and range of services provided within your business? This may include considerations such as your business turnover, number of clients, nature and sophistication of your client base, and the number of relevant staff. How complex are the services you're providing and supervising? How many qualified and experienced staff do you have, and how often do they undertake training and development activities? What supervisory arrangements do you have in place, including quality assurance and control practices and escalation procedures? What are your risk management processes? And does your entity have a condition imposed on its registration by us? So, when you nominate a registered individual for your practice, make sure you assess their capacity to undertake supervision on behalf of the entity, while also providing a competent service to their own client base if they have one. And within that, taking into consideration all the factors we've just outlined. It is up to you to assess how many registered individuals your practice needs to provide competent services and adequate supervision. And you must be able to demonstrate that you satisfy that sufficient number requirement when we request you to do so. In addition, when appointing registered individuals to provide supervisory services for your practice, you must obtain their prior informed written consent. Now, this is an important change in our requirements and will be included in our finalised guidance, which will be published shortly on our website. Now, you may think, what does prior informed written consent mean? It means that you must ensure the nominated individual has considered all the relevant information before agreeing to take on the supervisory role, including the nature of the supervisory arrangements in place and the supervision and control to be undertaken. The nominated individual must give a written signed statement to you to provide their consent. This will ensure that the individual is aware of their appointment as the responsible supervisor and understands the requirements of the role. The only exception where the prior informed written consent will not be required is in situations where you have existing documentation that sets out the nature of supervisory arrangements and supervision and control to be undertaken, and the nominated individual is aware of and understands the obligations set out in the documentation. Right, so now let me explain the sufficient number requirement a bit more for tax financial advisors through a couple of scenarios, as we recognise they have different business models when compared to tax and BAS agents' businesses. This is partly due to the licensing requirements under the Corporations Act. For scenario one, Australian Financial Services Licensee, or AFS licensee for short, operates under an authorised representative model only. That is, they have corporate authorised representatives and or individual authorised representatives only, and no employee or other representatives. All the authorised representatives provide tax financial advice services for a fee and are registered with the TPB. So in this scenario, the AFS licensee will meet the sufficient number of requirements, as all their authorised representatives providing tax financial advice services are currently registered with the TPB. So the individual authorised representatives and or the registered individuals of the corporate authorised representatives will form the sufficient number and help meet this requirement for the AFS licensee. The AFS licensee should not have to register more individuals to assist in meeting the sufficient number of requirements in this case. In scenario two, an AFS licensee operates under a business model that includes both employee representatives and authorised reps. They may be either individual and or corporate authorised reps. These authorised representatives provide tax financial advice services for a fee or reward, and the employee representatives all provide tax financial advice services on behalf of the AFS licensee. So in this scenario, if all the authorised representatives are registered with the TPB, but none of the employee representatives are registered, then the AFS licensee will not meet the sufficient number requirement, because there is no registered individuals within the licensee structure itself. So to meet the sufficient number requirement, the licensee will have to register individuals from within their structure. The licensee will need to determine how many individuals should be registered from within their structure to meet this requirement, taking into consideration the factors we discussed earlier. The licensee can choose to register individuals such as the partners, directors, employees, or employee representatives, contractors, compliance officers, etc. of the licensee. However, these individuals must be competent and capable of providing effective supervision. The fact that the authorised representatives are registered with the TPB in this instance is not a relevant consideration to determine how many individuals will form the licensee's sufficient number. Right, so let's now discuss how to determine if you have adequate supervisory arrangements in your practice. The term adequate supervisory arrangements may broadly be considered as arrangements aimed at directing, overseeing and checking the services provided on behalf of a company or partnership entity to ensure those services are provided competently. To determine if your practice has sufficient supervisory arrangements, we will assess what measures you have taken to provide effective supervision and control for relevant activities according to your circumstances. Now, we've taken guidance from previous Administrative Appeals Tribunal cases that were decided under the Income Tax Assessment Act of 1936 to determine some of this, or to provide this guidance. These cases established a number of principles on what constitutes a sufficient degree of supervision and control. These principles were established in the context of the requirement that an agent have some relevant employment experience before being registered, and the prohibition of registered tax agents from allowing unregistered entities to prepare statements for a taxpayer required or permitted under a tax law and conducting business on behalf of the registered agent. The above principles are equally applicable to the TASA, as we've seen earlier when I spoke about how supervisory arrangements under the TASA are important in the context of relevant experience and civil penalties. So what should you consider to determine if there are adequate supervisory arrangements in your practice? The level of depth and oversight undertaken over the tax agent, BAS or tax financial advice services being provided in your practice is an important initial consideration. Merely checking a document to see if it seems reasonable is not sufficient. There must be substantial supervision. This means there must be ample or considerable amount of involvement and not simply checking from time to time. While you do not have to necessarily monitor or oversee all work or client interviews done by your staff, there must be adequate supervision or oversight provided. Of course, this would vary according to the skills and experience of the staff and the complexity of the services being provided. Supervision and control must be exercised on the relevant activity completed for a taxpayer that is required or permitted by a tax law, such as completing an income tax return or an activity statement. It must include periodic and spot checks of material prepared by staff. Importantly, you don't have to necessarily have an employer or employee relationship with the person performing the services to provide adequate supervision. So additional considerations. Further, you can consider adopting a range of other measures to ensure there is adequate supervision and control. Before you sign a declaration or statement in a tax document in relation to a taxpayer that has been prepared by someone not working under the supervision and control of a registered tax practitioner, make sure you check the accuracy of the declaration or statement you are signing. Ensure the staff have adequate level of education and understanding of the relevant tax laws to execute the tasks they are responsible for. Provide initial and ongoing training to your staff. Have documented procedures and processes in place so staff can raise any issues with their supervisor that are beyond their knowledge, or if there's been any specific issues or concerns raised by your clients. Implement quality assurance and quality control mechanisms and conduct regular quality reviews of work undertaken by staff. And undertake spot checks of the source documents and questions asked by staff to justify any income and deductions declared. So one mechanism that we highly recommend you adopt to ensure you have adequate supervisory arrangements is to develop a plan setting out the supervisory arrangements. The plan should be set out, I'll just move that forward one if we could. Thank you. So supervisory plan. The plan should set out the processes and procedures for supervision covering the considerations we just discussed. It should help the nominated supervising tax practitioners to clearly understand what their responsibilities are and that of the staff under the plan. And having such a plan should help you establish the supervisory processes for your practice and help you to comply with your obligations under the code. It also enables you to have evidence of what you've done if it's ever queried by the TPB. So now if we move on to remote supervisory arrangements, let's look at some of the relevant considerations on this topical matter. I'm sure many of you are now used to working and interacting with colleagues remotely thanks to the pandemic environment we're living in at the moment, and also due to the technological advancements that have allowed remote working to become so commonplace. When we refer to remote supervisory arrangements, we are referring to arrangements where the supervisor and the staff they supervise in their entity are in different locations. We're also referring to situations where the supervisor and the supervised staff are employed by different entities. So how do you ensure you have adequate supervisory arrangements when operating under these remote arrangements? While it will depend on your particular circumstances, the following considerations can be useful. What's the frequency of contact and methods of communication between the supervisor and staff? Is the supervisor available to be contacted by staff at all times? Can staff access training and research resources while working remotely? Is there workflow management in place, particularly where the supervision and control is being provided by a different entity? How will documents be reviewed and feedback provided to the staff? Do you have systems that will allow reviews to be undertaken remotely? Is the registered tax practitioner supervising one or several entities? So as mentioned earlier, I again strongly recommend you develop a supervisory plan for remote working arrangements to ensure you have effective supervisory arrangements in place, which are well documented and able to ensure you comply with the code. We will be satisfied there is adequate remote supervisory arrangement where there is a structured arrangement in place, including documented procedures and processes specifically for remote working arrangements. Where the remote supervisory arrangement is clearly set out in that supervisory plan, where there are regular training and check-ins with staff and regular review of documents prepared by staff, and where there is clear communication of expectations on how work will be completed and reviewed in a timely manner. So, holding multiple supervisory roles. We acknowledged earlier that a registered tax practitioner may be a nominated supervisor for one or more related or unrelated entities. In this situation, all the considerations we discussed earlier are relevant in determining if adequate supervisory arrangements are in place. In addition, you need to also consider the size of each entity for which the individual is the nominated supervisor. And it can include factors such as the turnover of the business, the number of clients, the number of relevant staff, the market segment of the client base of each entity is important, the type and complexity of tax agent, BAS or tax financial advice services being provided or supervised, and other professional duties or responsibilities of the nominated supervisor. So in relation to this one, I strongly encourage you to review our guidance once it is finalised and published on our website, which will include a scenario in relation to this to help put it into some context for you. So, penalties and sanctions, consequences for failing to comply. If a company or partnership tax practitioner does not have a sufficient number of registered individuals or supervisory arrangements in its practice, it can breach the TASA. So if you find that a tax practitioner has failed to comply with the TASA, and in this case the Code 7 item, specifically, we may impose one or more administrative sanctions or seek a court-imposed civil penalty. And sanctions can include written and formal cautions, one or more orders that may require the tax practitioner to do certain things, such as completing a course of education or training we might specify, limiting the services you may provide, appointing additional registered individuals in the practice to provide the supervision and control, providing services only under the supervision of another tax practitioner. It can also include suspension of registration or termination of registration and prohibiting the entity from reapplying for registration for a period of up to 5 years. And the severity of that sanction obviously depends on the nature and extent of the breach and the individual circumstances of each case. Where sanctions are imposed, the practitioners have a right of review with the Administrative Appeals Tribunal. That tribunal obviously provides an independent review and may publish its decisions. We are also able to apply to the Federal Court, which can impose a penalty for each breach, and the maximum penalties can be up to $52,500 for individuals for each breach, and for corporates up to $262,500 for each breach. So finally, I'd like to move on to a case study in relation to having no supervising agent. So these cases involve matters where a lack of sufficient number of registered individuals and adequate supervisory arrangements were brought before the Board Conduct Committee, the BCC. First case we're going to discuss involves a company tax agent that lodged 96 returns and statements when it did not have any supervising registered tax agent individuals. The company declared in its 2019 annual declaration to the TPB that its director was the registered individual providing services on behalf of the company. However, the director was no longer registered as he had failed to renew his registration. The company failed to respond to our inquiries, and there was no evidence that another supervising agent had been appointed by the company. The company therefore failed to meet the registration requirement of having a sufficient number of individuals to carry out supervisory arrangements and ensure tax agent services were provided competently. As part of the review, it was also found that the company did not comply with its personal tax obligations by failing to lodge its 2018 and 2019 income tax returns when due, failing to lodge its annual GST returns for 2017 and 2019 years when due, and failing to pay its tax debts on time. The BCC determined that the company breached the code by failing to respond to our inquiries, knowingly making a false claim in its annual declaration in relation to the supervising agent, and failing to comply with tax laws in its personal affairs. On the basis of these findings, the BCC terminated the company's registration as a tax agent. You can see the implications there of not meeting the requirements. The next case study. In this case, the company tax agent had two registered individual tax agents nominated to provide supervision. It was found that the company failed to provide competent services and adequate supervision to nearly 3,000 clients in its client base. Audits by the ATO showed the company agent had claimed work-related expense deductions for 13 clients in their 2018 tax returns without appropriate substantiation. Tax agent also had failed to ensure a business activity statement lodged for a client contained accurate information and the required substantiation before lodging it with the ATO. The agent was found to have failed to apply tax laws correctly in making the work-related expense claims and also in claiming rental property deductions. The BCC determined that the outcome of the ATO audit showed that the company lacked appropriate supervisory arrangements to ensure competent services were provided to its clients. Taking into account the nature of the breaches and the mitigating circumstances provided, the BCC imposed a written caution on the company, an order that the company nominate an additional supervising registered individual tax agent for the company, and an order that the company's two supervising tax agents complete a course in practice management. So that brings us to the end of the formal part of it. To finish our webinar today, I'll hand over Madeline to share some of the questions that have been coming through during the session. Madeline.
Great, thanks, Craig. Got quite a few questions here for you. And the first question is, during COVID-19, I've changed my business structure by increasing the number of employees I have. Do I need to provide details of their supervising agents?
Yeah, so assuming your sufficient number requirements needs have changed, so because of the increasing number of employees, the existing number may now not be sufficient, then you need, and so you need more registered tax practitioners to supervise the employees. Yes, you need to notify us. Notifications, as I said earlier, need to be submitted in writing within 30 days of you knowing that you need to increase your sufficient number. And I think they can be completed on a contact form on our website at www.tpb.gov.au. And I think there's a spot there to select change your registration details.
Great, thanks, Craig. The next two questions relate to the supervisory plan that you spoke about earlier in the webinar. And the first question is, what should a supervisory plan include or cover?
Okay, supervisory plan, well, It has to set out the processes and procedures you have in place to ensure that the tax agent, BAS agent or tax financial advice services provided are of a competent standard and that there is adequate supervision and control in place. So what should include it may cover things such as the steps to be taken or processes that are in place to ensure the accuracy of information prepared by an individual in relation to the declaration or statement to be signed by the tax practitioner. May include the ongoing training or initial training, ongoing training to be provided to staff that are being supervised, how staff, in what circumstances staff should raise issues with their supervisors that are beyond their knowledge or experience, how frequently there are audits of work undertaken or reviews of work undertaken by staff to ensure the level or the standard of work being prepared, so those, and the review procedures that we'll utilise, and I think I mentioned spot checks and source documents, so when and how frequently they should be undertaken.
Excellent, really good advice there. The next question is, will having a supervisory plan mean that I have adequate supervision and control arrangements in place?
As I said on the way through, we strongly recommend having a supervisory plan in place as it assists you in establishing and getting a clear understanding of the responsibilities of the supervisors and the staff to ensure that there is adequate supervision and control. So I strongly recommend that. However, having that by itself does not necessarily demonstrate that there is adequate supervision and control. It's a case-by-case basis. We would look at the plan in place, look at how that works within the practice to determine that it is appropriate. But having it is certainly a good step in providing us with evidence that you have arrangements in place that meet that requirement.
Excellent. The next question is, if a tax practitioner misses a mistake made by an employee who is not a registered tax practitioner, will the supervising tax practitioner be penalised for that mistake?
So in this case, the registered tax practitioner is the responsible party. So at all times, they are responsible for errors made or mistakes made by an employee. So that's why the supervision and control we talk about is so important. The CPV doesn't require a tax practitioner to check every return. We talk about periodic spot checks. We talk about the other supervision that you have in place. So the important thing is to have the appropriate processes in place first. So it's one error wouldn't necessarily get you penalised if you can demonstrate that you have appropriate processes in place. That's the important part of it. But you do need to understand that the tax practitioner is the responsible party at the end.
Great, thanks for that. Do clients have the right to expect that any tax advice provided by a tax agent's practice is prepared by or signed off by a registered tax agent? As we've discussed, the registered tax practitioner is the responsible person for the services provided. However, there's no standard process to use when determining adequate supervisory arrangements, as it depends on the particular practice or business, and they vary from entity to entity. So what clients should expect is that there's adequate supervision and control in place, being overseen by the tax practitioner, rather than the tax practitioner has undertaken every step of the process. Great, thanks, Craig. The next question relates to sufficient supervision, and the question is, if a tax agent works part-time, but still checks the work of a tax practitioner working under them on the days that they're in the office, in your view, would that constitute sufficient supervision being exercised?
You would need to consider this on a case-by-case basis and review the plans and processes in place. There are some factors that would indicate that it may be fine. The supervision and control, so it's about the supervision and control, not just about physical inspection and supervision. So we'd need to consider the processes in place to ensure that they're robust enough that a part-time physical presence or physical supervision is fine. So it could be fine, but it would depend on the processes and is a case-by-case decision.
Thanks for that. And the final question I have here is in relation to offshore arrangements. How do registered tax practitioners who have work completed for them offshore meet the TPB sufficient supervision requirements?
Yeah, it's a topical question. So to determine if appropriate supervision has been exercised or if there are appropriate supervisory arrangements in place, again, will require an assessment of the measures taken by the tax practitioner to supervise and control the relevant activities based around their practice. We've still got to go back to the factors we've spoken about today and have a plan in place on how they are supervised. I believe we've published a practice note on this, on outsourcing and offshoring, which covers the factors that you would need to consider when entering into those arrangements. So maybe we can share a link to that after the webinar today, which might assist.
Great, thanks, Craig. You're right. We have published a practice note in relation to outsourcing and offshoring of tax services, and I'll shortly share that in the chat box. But I think Julie will also send that around following the webinar. That's all for the questions. So I'll hand back to Julie to talk about how the practitioners online can stay in touch with us. Thanks, Julie.
Thank you so much, Maddie. Yeah, just to finish up today, I'd like to share some information on how everyone can stay in touch. So if you'd like more information and to keep up to date with the TPB, obviously we've got our website available to you, which is full of helpful and useful information, and you can find the website at tpb.gov.au. You can also follow us on LinkedIn, Facebook and Twitter. We're constantly putting updates on social media platforms there, so that's another great way for you to keep up to date. We also have a newsletter that goes out each month, which is called TPB e-News. You can subscribe to that as well so that you'll be kept up to date each month with all the TPB happenings, and that subscription page is on our website at tpb.gov.au/newsroom. Another great way that you can stay in touch with us is to subscribe to our YouTube channel, and if you do that, you will receive notifications when we post any new content. So any new videos, you'll get an email from us to say, yep, we've done something new. So we do actually record all of our webinars, and we have a comprehensive library of webinars available for you to view at your leisure, and they're all on our YouTube channel as well. And the good news about that is that you can still claim your CPE or CPD for viewing these videos, so that's good to know. So just to finish up, I would like to thank Craig for providing all that useful information to us all today. It was great to hear from you, Craig. And thank you to Madeline as well for answering the questions through the chat box. That was really helpful too, Maddie. Thank you so much for that. And also just to everyone for joining today, thank you to you for coming along. And we do hope that you found the webinar beneficial. We do think that the webinars are a great way for everyone to keep up to date. And as we have said a couple of times today, it does count towards your continuing professional education. But also please do remember that we don't issue attendance certificates for people attending the webinars, but we will email you just notifying that you have attended today. So you can use that as confirmation of your attendance. So if you are interested in attending more of our webinars, just again go to our website and you can register for some upcoming events that we've got listed there. The web address for that is tpb.gov.au/webinars. And then the last thing today, before we do finish, I'd like to launch an exit survey, and we would really appreciate it if you could take the time to complete it. It's very quick, only takes a moment, and your feedback is really useful to us because it does help us improve on the webinars and also lets us know of any topics that might be of interest to you. So yeah, please take the time to do that. It will just pop up in your browser once you leave the webinar today. So once again, thank you for joining us today, and we do hope that you stay safe. And we know this is a very challenging time for everyone, so we do appreciate that you've taken the time to join us today. So thanks again, and enjoy the rest of your day. Stay safe.